Stovall, who's a commissioner. He's recused himself because of professional reasons. Thank you very much. That's to avoid any appearance of conflict of interest in this matter.
Thank you very much. I'd ask that the witnesses be reminded that they are still under oath and affirmation that was taken previously. Now, Madam, well, ladies and gentlemen, when we had paused on the last occasion yesterday, we were at slide number 53. I'm going to ask you to continue from there in terms of your presentation that was being made. The slide is being put in order. Ms. Stewart, you, on the last occasion, you had given evidence in respect of a number of documents which had been tendered, specifically letters written by Mr. John N. Darrell, and you had shared with us not just the letters, but certain documents in support thereof. I'm going to ask you to continue the exercise, Madam. Now, you had shared with us a February 25, 1992 letter from the Bank of Bermuda Limited addressed to Mr. John N. Darrell. I'm going to show you a document. Could you kindly identify it if you can? Is that the document that you shared with us, which you wish to use in support of your case, specifically documents and correspondence between Mr. John N. Darrell and other persons?
Yes, sir.
Chairman, it is dated February 25th, 1992. It appears to be the letterhead of the Bank of Bermuda Limited, and it is signed, a signature appears of one Simon M. Stones. I'd ask that this document is tendered and admitted as Exhibit HT19.
You just have a letter written by John and Darrell to the.
No.
Sorry.
It is addressed to John N. Darrell.
Addressed to John and Darrell from the Bank of Butterfield, it's on the Bank of Butterfield letterhead, dated Bank of Bermuda letterhead, February 25th, 1992, dated.
Thank you.
Exhibited as
HT 19.
19. Thank you.
Please read the document, Madam.
The Bank of Bermuda Limited, Head Office, 6 Front Street, P.O. Box HM 1020, Hamilton, HMDX, Bermuda. February 25th, 1992. Mr. John N. Darrell, 12 Radnor Estate Road, Hamilton Parish, CR01. Dear Mr. Darrell, As you are aware, you have substantial personal and joint indebtedness to the bank, all of which is in arrears. I have now been instructed to officially demand settlement of these debts, together with all interest, fees, and charges by 3 p.m. on Thursday, March 26, 1992. A schedule of the amounts owing to February 24th, 1992 is attached. Interest, fees, and service charges, etc., will continue to accrue on these balances to the date of the settlement. Failure to do so will result in the initiation of proceedings to realize the security we hold for your indebtedness, namely the sale of your property at Radnor Estate, Hamilton Parish. After receipt of proceeds of sale of the property, any balances then remaining will be subject to collection through our lawyers, Cox and Wilkinson. You are also reminded of your indirect obligation for the loan of $75,000 granted to your brother, James W. Darrell, together with all interest, fees, and charges, etc. As of February 24th, 1992, the total owing on this loan stood at $89,416.71. From our recent conversation, it is my understanding that you are making arrangements with your brother, which should result in repayment of this loan. Unfortunately, I have to advise you that payment is expected by the above date and further negotiation of this matter is not possible. Kindly acknowledge receipt by signing the enclosed copy letter. Yours faithfully, signed Simon M. Stones, Assistant Manager, Credit.
No, you have relied on this document for a reason, madam?
This document is being relied on because it speaks to the amount of debt that Mr. Darrell has accrued in trying to fight this case.
Thank you.
And I also want to note that this is just one bank. He has taken out loans of multiple banks, and we just wanted to include this just to speak to a portion of the debt that John Darrell accrued.
Thank you. Now, the document, on the other side of the document, there's information also,
Yes, sir.
and that speaks to just the actual layout of the money's own principal, interest, administrative fees, and late charges. Correct?
Yes, sir.
The figure there, what is the balance?
The first balance, or at the bottom.
Well, it indicates, just to assist, it indicates what appears to be a number of two loan accounts, a current account balance, and also some credit card balances. Is that correct?
Yes, that's correct.
Thank you. Now, what next, madam? There are some receipts. Are these, earlier you had made reference to receipts which evidence payment of taxes. Are these said receipts, or this is something different?
Yes, there are those receipts on the list, but also I want to bring your attention to the bottom receipt.
But let me just bring it to your attention first so we can
No problem.
make an exhibit before you can speak to it. You have the documents there you wish to rely on, madam?
Yes, sir.
How many documents are they?
It's 6 pages.
The first page has NO 473, number 473 on the first page, madam.
Yes, sir.
And the sixth page, what appears on the sixth page? This bill is payable on demand, number 474, is that correct?
Yes, sir.
I'd ask that those 6 pages, I'm sorry, Chairman, starting with a page which has at the top left-hand corner NO 473 and ending on the 6th page with what appears to be a photocopy of a document which bears NO 474. I'd ask that there be tendered and admitted as Exhibit HT20.
I would ask one question. Are these all receipts, Council? Or what are they? Specific?
They are all receipts, copies of receipts, Chairman.
We have before us 6-page copies of receipts, starting from page number 473, ending in page mark number 474, and we're entering as Exhibit HT20.
I think Mr. McNaughton wishes to say something.
Yes.
Yeah, there's a parish receipts for the property, or there's a
So these are parish vestry copies of receipts,
for the
more
property.
specifically. Thank
Yeah.
you very much, Mr.
Yeah.
McMillan.
Could I say something else?
Please.
Yesterday was a levy. A question was asked to Haley, and she wasn't quite sure the answer on the was exhibit HT6.
You wish to make a correction?
I wish to just clarify, make a correction, if it's possible.
Sure. The witness is indicating that in respect of Exhibit HG6, which is also being projected on the screen, at this time he wishes to
Yeah,
make a correction to
yeah,
some evidence that had been given, a question had been asked,
yeah.
and the witness, just a moment.
I'm
The
sorry.
witness wishes now, Chairman, to correct.
Yes, and what would the correction be?
Okay, the name George Wellington Darrell. Darrell George Wellington, that's my grandfather. That was my grandfather's name.
So this is exhibit entered as HT6.
Yes. On the occasion, a question had been asked yesterday, Chairman.
Yes.
Miss Tiart had spoken to the entry as it relates to Darrell.
Yes.
She had spoken to the top one, which was
Emilius Estate. The
No.
witness is now indicating that they are now speaking to the next entry, which appears next to 23 January, it appears 19.
No, this is 1942,
Thank you very much. They now wish to speak to that entry.
and that
But
name is my grandfather, Darrell George Wellington.
So what do you wish to do with this one,
what-
Council?
what
The
I-
exhibit, as far as entering as an exhibit?
Well, what I'd ask the record to reflect is that the witness is now is identifying in relation to the exhibit, is identifying on the document, which is the exhibit, recognizing another name, because this document, the purpose of this document, as we had been told, it is in proof of the claim.
Yes.
And they wish to indicate not only in relation to the first entry, some connection with the family lineage, but they wish to state that in relation to the second entry, there also is some relationship.
To the family,
Yes,
And-
Chairman.
namely George
George Wellington, my
George
grandfather.
Wellington Darrell.
Yeah, that's me as his son.
Okay, so right there. Sven, let me get that. George Wellington, is it?
Wellington.
Do you wish to put HT, yeah, A or B?
No,
No,
I just
or you
wish
leave it as it is?
as it is, but just
Yes,
the
just an addition.
yes, it is just a further evidence
Yes,
in support of the claim that is being made, Chairman.
thank you, sir.
Welcome.
I'll make a notation. Thank you very much. Mr.
McMahon.
McMahon, yes, I have to,
Ms.
No
Tiart, would
problem.
you wish to take us through the
Thank you.
documents? What's exhibit? Not that one. We'll soon have the HD 20 displayed again.
D. HT.
Yes, we're on the first page, madam.
Yes. Okay. So the first half of that page shows a receipt from Amelius Darrell to the
That's
South-
just take your voice a little louder, please.
to the Southampton Parish Vestry of £400 in 1950. The second half of the page actually
That's September 10, 1950.
yes, September 10th, 1950.
Thank you. And the second half of the page you're saying?
It's actually talking about E.T. Richards and the payment from George Wellington Darrell to him for professional services that were not completed related to the conveyance of the property from Amelius to John Darrell.
They were not
Completed. We earlier in our presentation we talked about why the estate of Amelius Darrell is still called the estate of Amelius Darrell rather than George Darrell or John Darrell, and that's because the conveyance was never completed by E.T. Richards, and this is receipt proof of services that were supposed to be provided.
This receipt is dated the 3rd of February 1940. It's not clear, the receipt as to the year. Are you able to assist us?
Which one is it?
I think it says 1950.
53.
Do you see the
1950.
number up in the top? Yes.
Thank you. I also see a 4, that's why I was
It
asking.
looks like it's scribbled out. Looks like that.
But just to be clear, and I'm not putting words in your mouth, but this receipt, you'd agree with me, it suggests that there are professional services being provided by Mr. E.T. Richards to George Darrell, Esquire, correct?
Yes, it suggests that George Darrell paid E.T. Richards for professional services to be completed.
Okay. But in respect of your evidence that it was in relation to a conveyance, that's not displayed here on this receipt. You're just
No, but we are using this to support John Darrell's claim that their professional services were never completed in terms of that being the conveyance.
Okay. All right, thank you. You may go to page 2, thank you. On page 2, the next receipt, at the top of the page, it says number 55.
Yes, sir. This is again another receipt from the Southampton Parish Vestry, 1948, for £400, September 29th, 1948.
Thank you. The next receipt.
The next receipt is also September 29th, 1948, from Mr. George Wellington Darrell to Southampton Parish Vestry for a different amount.
Page 3.
Page 3 is a bill to George Wellington Darrell from the Parish Vestry for £200. This is 1967. And on the right-hand side of that is another bill payable on demand from the Southampton Parish Vestry, re the estate of Emilius Daniel Darrell, under George W. Darrell, for £2,000 in 1967.
I make a distinction. The document on page 3, which has number 55 at the top of the page. We have two sections on that document where we have received payment and a signature and a date. It appears on the first half where it has borrows, AC Borrows, and the name Estate of Emilius Daniel Darrell. On the second receipt, it has Mr. George Wellington Darrell for £100. Received payment, date 29th of September 1948. But on the third page that you are just referencing, there is no signature of payment received on this or the other document. But this is just as it says, a bill is payable on demand, but no indication that a payment was made. So you exhibit this just to show, however, that there was a existing relationship between the parish vestry and the Darrell family in respect of paying dues. Correct?
Yes, that's correct.
Just a query. On the document that's displayed, the amount appears to be 200 rather than 2,000. Pardon, am I correct? Which one are you referring to? The one that was just had the green stamp on it, if you roll back. That one. Could you check and see what the sum is, Bill? It looks like 200 rather than 2,000.
The first one that has at the top of the page 122 at the top left-hand corner. We can't rotate it at this time. My apologies.
I can see
that
one.
one has $200.
Yes, there's 122 at the top. Is that the one referring to?
That's the one. And based on your observation, the following one, which has number 121 at the top of the page.
Yes, okay, that's the next one then.
That
Yes,
one
correct.
has what appears to be 2,000.
Yes, correct. I was looking at the wrong document.
Yes, pounds, I'm sorry.
Pounds, yes.
My apologies.
All right. It's been cleared up.
You may proceed, madam, to the next page.
This next portion of the document references a 1971 receipt on the estate of Emilius Darrell by Mr. George Darrell. This is paid, and then the other half of it is from, I want to say 1971, again, paid by Mr. George Wellington Darrell, specifically for Riviera Estate, Southampton East.
Thank you. And the final page, madam.
This portion, I'm sorry, there's one more portion on the bottom of the page that we were just looking at. And it's a bill for Mr. Emilius.
Please keep your voice up. Just a minute. You may proceed, madam.
This bill is from Mr. Emilius Daniel Darrow, or the receipt, and it is for October 25th, 1947. However, George Darrow's name is listed here by received payment.
Thank you. And the final page. What is that, madam?
The final page is a bill payable on demand to Southampton Parish Vestry on the estate of Emilius Darrow for £400. And this it appears to be October 1st, 1954.
Thank you. Now, the following document, next document that you have shared with us and which you wish to place reliance on is a document which had been filed in the Supreme Court, and it speaks to Mr. John Nathaniel Darrell suing the Minister of Works and Engineering, as he then was Dr. the Honorable Clarence R. Terciera.
Tessera.
Thank you very much. Is that correct, madam?
Yes, sir.
How many pages does it comprise of, madam?
5 pages.
And you wish to place reliance on that document, madam?
Yes, sir.
I'd ask that to be tendered and admitted as Exhibit HT 21.
And for clarification, would you repeat the description of that exhibit, please?
I
Counsel?
crave your indulgence.
Yes.
It is headed in the Supreme Court of Bermuda, civil jurisdiction,
Supreme Court of Bermuda Civil Jurisdiction.
between John Nathaniel Darrell, plaintiff,
Between John Nathaniel Darrow, plaintiff. Yes.
and the Minister of Works and Engineering,
And the Minister of Works and Engineering.
in bracket, Dr. the Honorable Clarence R. Dr. the Honorable Clarence R.
Dr. Clarence R. Teixeira.
To Sarah. The statement of claim.
Teixeira. Statement of claim, and that's now tendered as Exhibit HT 21, right?
Correct. And you seek to rely on this document for what reason, madam? Sorry. Go
Just
ahead,
one
Chairman.
clarification, the date, please, of that civil matter.
It doesn't have a,
It appears to be 1992 in the document.
Yeah.
well, that would just be a generic number, but the file number is not there. I was just trying to.
Yeah.
There's a number 18 that appears at the top left-hand corner, but
There appears to be a number at the very top under the heading in the Supreme Court of Bermuda, 1992.
I appreciate that. That is so,
Yeah.
Chairman. I was just indicating that it does not appear that the registry wrote in if that was a practice of the number, the file number.
Yeah.
Because this appears to be a copy.
Yeah. That's okay. And in the top left-hand corner, it seems like a number 18 marked on the sheet, and that should be sufficient to identify the
Yes, Chairman.
document. Thank you.
Why do you wish to rely on this document, madam?
This document just shows, again, one of the many attempts at John Nathaniel Darrell to lay claim to the land.
And to ask you to keep your voice up for me.
Sorry.
I'm just going to ask you may read what had been filed in the statement of claim. You may go ahead on page 3.
Statement of claim. 1. The plaintiff is the son of George Wellington Darrell, who in turn was the son of Emilius Darrell, who in turn was the son of Daniel Davis Darrell. 2. The plaintiff's grandfather, Emilius Darrell, died on the 8th of August, 1947. 3. A plan attached to the deed of 1912 describes the land on the 1939 deed, showing Emilius Darrell's ownership of the 3 parcels of land as one. 4. The defendant obtained portions of 2 parcels of the aforementioned lands. 5. Further, the defendant obtained the entirety of the Foster Mallory Cooper's lands. 6. The defendant's acquisition of the aforementioned parcels of land was affected by fraud. Particulars. 7. Deeds of 1922 and 1924 fraudulently show the ownership of the said lands by the defendant. 8. The J.H. Dale Plan of 1932 shows that the aforementioned deeds of 1922 and 1924 are fraudulent. It refutes the 1930 plan, and defendant acquired lands that were never sold by Emilius Darrell. 9. The 1939 conveyance from Miss Joan O'Flaherty to Mr. Gaius Powell, drawn by Messrs. Conyers, Steele, and Pierman, refutes the railway company's ownership and the defendant's subsequent ownership of lands properly belonging to Emilius Darrell. The 1963 conveyance from George Arnold Williams to Erman Jarvis, drawn by David, I can't say that word, Tucker, attorney, as well as a 1943 plan by Wycliffe Stubble, confirms the west boundary to be that of the estate of Emilius Darrell. 11. The Southampton Vestry, the highest authority in the land ownership, confirmed the estate of Emilius Darrell and the portion of property of George Wellington Darrell, which at this time was still the property of George Wellington Darrell. 12, due to fraud on the part of government and the Southampton vestry, the Department of Planning was misled by a 1953 plan. 13, in 1926, the government
62.
Pardon me. In 1962, the government posed its first resistance to the ownership of the portion of property which it alleges to have received from the railway company. 14, the 1959 deed, a conveyance from Gaius Powell, acknowledges the government's ownership to the railway company portion of property, but goes on to contradict the 1953 plan and the 1922 conveyance to Claudia Darrell and from Claudia Darrell to Percy A. Dogwell. It also contradicts the deed of 1924. This same 1959 deed further contradicts the assertion of the Southampton vestry that Amelius owned only 75 feet by 100 feet of lands, but rather very much more. The aforementioned instances of fraud show that the government never owned in law or in equity the railway portion of the property which it alleged to own in 1939. The same property in this conveyance is that of Amelius Darrell. By reason of the above instances of fraud, the plaintiff, has suffered loss. Particulars of loss of lands, attorney's fees, those remain empty. And it says the plaintiff's claim is for damages, alternatively restitution of lands, the aforementioned interest in pursuant to statute, and declaratory relief. Signed, Philip J. Parent, Chief, Associates, Attorneys for the Plaintiff.
I'd like to, for clarification, indicate that Philip J. Parentchief is my brother.
No, thank you, Chairman. Now, in respect of the document HT 21 that you just referred to, there is a judgment which was given in respect of this matter. You wish to rely on it, Madam?
Are you referring to this?
No, that was a document filed in court, and I'm saying there's a judgment. The court issued a ruling in respect of those documents filed.
I don't believe we have that attached here. Do we?
Well, you had given it to us. I was going to show you the judgment. You recognize that document? Have you seen that before?
Yes, I do.
How many pages is it?
It is 4 pages.
Chairman, the judgment of this Supreme Court, at the top of the page, it has NO 4A, number 4A. It indicates in the Supreme Court of Bermuda, Civil Jurisdiction, 1978. Number 124. The Minister of Public Works, plaintiff, and John Darrell, defendant. Before the Honorable Mr. Justice Robinson. Asked that this be tendered and admitted as Exhibit HT 22.
Wish to tender an evidence as HT 22, judgment in the Supreme Court of Bermuda, number indicated as number 4A, before I say the plaintiff, Mr. John Darrow, the plaintiff being the Minister of Public Works, defendant John Darrow, before Justice Walter Robinson,
Yeah.
be tendered in evidence as HT 22.
Could you please go ahead, madam, read the document for us? Just a moment. Please go ahead, madam.
Okay. In the Supreme Court of Bermuda, Civil Jurisdiction, 1978, number 124, the Minister of Public Works, plaintiff, and John Darrell, defendant. Mr. Robin McMillan for the plaintiff, Mr. Vacrossant for the defendant. Before the Honorable Mr. Justice Robinson. Judgment. In this action, the Minister of Public Works, hereinafter the plaintiff, seeks against the defendant, John Darrell, 1, a declaration that the plaintiff has absolute title and complete beneficial interest in land at Southampton Parish in these islands, and 2, an injunction restraining the defendant by himself or his servants or agents or howsoever otherwise from entering upon the said lands in any way at all. 2, the land in question is a portion of a tract of land in Southampton Parish, aforesaid, upon which the Heron Bay School and its playgrounds are cited. 3, the plaintiff alleges that the defendant has on diverse dates entered upon the land asserting title thereto in his father, George Wellington Darrell, and that on 26th of October, 1977, the defendant entered the land and damaged fencing, which the plaintiff had erected by tearing it down, and that the defendant persists in trespassing upon the land despite being requested not to do so. 4, the plaintiff's case is that the land upon which the defendant persists in trespassing belongs to the plaintiff in his capacity as Minister of Public Works on behalf of the Bermuda government, and in support of his case, the plaintiff has produced a considerable number of deeds and vesting statute, showing the transfers at one time or another of separate parts of the whole tract of land behind Heron Bay School, and ultimately devolution to the Bermuda government, the latest of which, Exhibit 16, was executed in 1952. The plaintiff has also put in evidence certified copies of orders of this court dated respectively the 16th of May, 1974 and the 22nd of July, 1978, showing that the defendant's father, George Darrell, has been restrained by this court from entering upon the government of Bermuda's land south of the Heron Bay School as shown on Plan 4963, attached to one of the orders, which comprises all the land shown on Exhibit 2A, edged in various colors. Since the above-mentioned orders are operative against George Darrell, and the defendant is the lawful attorney of George Darrell, his father, as appears from a power of attorney by deed poll dated 22nd of February, 1977, which the defendant has exhibited, those orders are sufficient in themselves to dispose of the defendant's allegations of title in his father and the defense he has pleaded. For as the attorney of his father, he can be in no better or different position with respect to the title to any land than or from his father under the agency arising by virtue of the said deed poll. The plaintiff presumably has been obliged to take this action because while the orders cover the position where the defendant purports to act in right of his father, George Darrell, they do not affect the defendant where he purports to act in right of his own right in asserting any entitlement to enter upon the land in question, and that being so, some difficulty may arise in the enforcing of those orders and deciding when the defendant might be acting in his own right as distinct from acting in right of his father. By his defense, the defendant has alleged that the plaintiff is not the owner and occupier of the land in question, which he claims as belonging to his father, and says that the plaintiff was not entitled to fence the said land. He admits pulling down the fences, saying he did so under the authority of his father's title to the land. No documents have been produced by the defendant to substantiate his claim, either showing title in his father or grandfather through whom the defendant seeks to assert a right to be on the land. In fact, the defendant says neither his father nor himself can show any title deeds, even for the property whose title is not in dispute in this case. The defendant has produced 3 certificates of birth, which are the dates of birth of himself, his father, and his grandfather, but those certificates are not proof of the title in any of them or any land are useless for any such purpose. Any information which the defendant has had at all as to the whereabouts of any deeds that would establish title in himself or in his father is shown to be secondhand and unreliable, said the defendant. I have no deeds because they are placed in an office and we never got them back. I was not there. I was told about it. However, the defendant also gave evidence that over a period of some years, his family lived in a house nearby, which is still owned by his father, and that on a portion of the land north of what was the boundary line of the properly formerly of the Bermuda Railway Company Limited, his father and his grandfather had cultivated a garden, the cultivated area being between the Sail Road Railway Company's property and the southernmost cliff face of a cutting made by the Department of Public Works for the purposes of providing additional playgrounds for the infants at the Heron Bay School, which cutting is shown as the more southerly on the plans. Exhibit 2A. From the evidence as to such cultivation given by the defendant, it is not certain for how long or what time the same took place, nor whether it was continuous, with or without permission of anybody. Though the defendant testified that his family had done many things on the land, that there had been during the 1940s an American camp on the land, and that he had grazed goats and cows on the land until about 1957 when he was married. From these acts, uncertain as to time and duration, and as to the terms upon which they were enabled, the defendant proposed to set up a title in his father or himself. There may be in some circumstances a presumption of cessation from evidence of actual possession of a house or a field or farm, as in this case, a cultivated garden or grazing lands, but I have not been able to find an authority for extending the application of such presumption to the larger tract of land reaching up to the hilltop next north of Sunnyside Park area of the land of the government, which the defendant also claims, particularly in the absence of any evidence of a sufficiently continuous occupation as would justify holding that there was sufficient possession to displace the plaintiff's right to land, which is the subject of this action. To my mind, in order for the defendant to successfully defend this action, he must show such open, notorious, continuous, exclusive possession or occupation of such parts of the land as would constructively apply to all or any parts of such land as are claimed by him, and operate to extinguish the title of the plaintiff or the true owner, and give the defendant a statutory title under and by virtue of the relevant statute of limitation. In this case, the Crown Claims Limitation Act 1872, wherein the limitation period is 60 years. The onus of proving such continuous possession and occupation lies squarely on the defendant who alleges it, and in my judgment, the quality of whatever use there may have been to part of the land in question by or on behalf of the defendant's father or himself has not been proved in this case so as to establish any claim of right on the part of the defendant sufficient to justify holding that the plaintiff's entitlement to the land in question has been displaced. There is no substance in the defense nor in the claims made by the defendant, and therefore judgment will be entered for the plaintiff with cause. I also order a declaration in terms of subparagraph 1 of paragraph 6 in the amended statement of claim and an injunction restraining the defendant by himself or his servants or agents on howsoever otherwise from entering upon the government land shown in Exhibit 2A in any way at all. Signed, Walter N.H. Robinson, Pusine Judge.
Thank you. This judgment was not in favor of John Darrell. And from yesterday, we're aware that letters were read into evidence where the where Mr. John N. Darrell had been critical of the role of Judge Robinson at the time of the hearing, as also the role he played prior to the court case. Do you have any comments with regards to this, especially this document which now supports the view of John Darrell that
Yeah, one second.
Justice Robinson had made decisions in circumstances where he may have been conflicted?
Yeah, I will comment on that.
Could you just state your name for the record?
Donald McMahon. Okay. Before he was an attorney, I'm a judge. He was an attorney, and he done work for the Sunnyside Park, which is on top of the hill, and he also worked for the Darrell family. He worked for us in from the 15th of April, 1963, when he was investigating the boundaries. Then he had another letter dated the 17th of June, 1963, when he stated that he was continuing the search for the relatives, search related to the boundaries. And in 1964, he signed a forged document in favor of W.G. Brown and John Nathaniel Darrell. And so basically, he worked for us as an attorney for my grandfather, searching the boundaries out. And then he done a judgment, judged the case, which to me is he shouldn't have done that because it's conflict of interest, I think. But he was he worked for us, finding the boundaries, then he turned around and put judgment on a case where he knew all about the property.
Thank you very much. No. Go ahead. Just have her state her name, please.
Cynthia Fishington. Continue with what Donald has just said.
Yes, ma'am.
That case, before it even went into court, it was lost. In other words, he should have stepped aside, like
He
Donald
who?
said.
He who?
The judge, Robinson, he should have stepped aside and let someone else judge it because it was conflict of interest, but he judged it. And it was the second case as well, where the person was a prosecutor in the case prior to that, and he became a judge. And so he also should have stepped aside and let someone else judge it. Those two cases, before my brother had even stepped into court, they were lost. They were, he didn't get a good ruling on that. So that's one of the things I would like to point out.
Thank you.
Thanks.
Now, the next document you wish to rely on is a photograph. Is that correct, ma'am?
Yes, sir.
And what does it depict?
This is just an image of John Nathaniel Darrell and a couple of other people blocking the Riviera Estate Road. And this is 1987.
And how do you know this? That's what it depicts.
Nathan Darrell. I knew of this photo because I was actually there.
How old are you then? You can say about how old? Or what year was it?
This is 1986. So I was 13 years old. 13 years old.
13 years ago.
13 years old.
13 years old. Sorry. Thank you. Now, I'd ask her that copy of a picture, which the witnesses indicates is a blocking of a roadway, and the roadway is
Riviera State Road.
The roadway is Riviera State Road. It's the portion of Riviera State that is right outside the house of the homestead where my grandfather stayed and my
okay. You
grandma.
have to speak into the microphone for me.
It's the house. It's the part of road right outside of the homestead, which is on Riviera Road. I think it's number 29.
Thank you.
Yeah.
Cool. I'd ask her that image, which is a copy of a picture that it could be tender admitted as exhibit HT 23.
Yeah, a
Would it-
photo of Jay and Darrell blocking the Riviera Road, a copy of it, as witnessed by Nathan Darrell. A witness who was 13 years of age at the time. He designated exhibit HT 23.
Thank you. Could you tell me who the persons are in the picture?
The person that's standing up on the hill, that is my brother, John Byron Darrell. The next person to him is a reporter. I can't remember who it was. Next to him is my father, and then there's the cameraman over on the side.
Thank you.
And the exact year would have been, if you count back from when you were age 13.
1987. 1987.
1987.
Yes.
Thank you. Now, Madam, a 5th of August 1955 letter on the letterhead of Appleby, Sperling, and Kemp is the next document you wish to place reliance on, Madam.
Yes, sir.
The letter is addressed to Mr. George Wellington Darrell.
Yes.
I'd ask for that document, Mr. Chair, be tender admitted as exhibit HT 24.
Yes, 5th of August 1955 letter from Appleby, Sperling, and Kemp to J.W. Darrell, be exhibited as HT 24.
Please read the document, Madam.
Appleby, Sperling, Kemp, barristers at law, Sperling, Kemp, Moitier, and Vesey, Reed House, Hamilton, Bermuda, 5th of August, 1955. Mr. George Wellington Darrell, Southampton East. Dear Sir, since you last spoke to our Mr. Moitier, we have had an interview with Mr. George A. Williams and also with Mr. Gaius Powell concerning the tract of land to which you claim to be entitled in the vicinity of Camp Hill. Mr. Powell was speaking to us both as the parish vestry clerk of Southampton and also as a landowner in the vicinity of your property. He tells us that the Paris vestry records show that a piece of land measuring approximately 100 feet by 70 feet was in the possession of William Green Darrell in 1864. In 1881, it was in the possession of Daniel Davis Darrell, and in 1939, it was entered in the vestry books as being in the possession of Emilius Daniel Darrell, and thereafter in your own possession. Within this long period of time, nearly 100 years, there is no record of any other land in the vicinity belonging to your predecessors in title. Mr. George A. Williams confirmed these same facts to us at the time of his interview. We have today had a consultation with Mr. Peter Smith of Messrs. Hallett, Whitney, and Patton, Mr. Williams' attorney, who has shown us Mr. Williams' title deeds to a tract of land somewhat larger than 5 acres situated to the south of your small lot. Mr. Williams' deeds show a clear title back to the year 1928 and recite a title going back to the latter part of the 19th century. On examining Mr. Williams' title deeds, we are satisfied beyond any doubt that these deeds are in perfectly good order and that there is no question that, at least against yourself, Mr. Williams has a good title to his tract of land. In these circumstances, and in the absence of any concrete evidence from yourself as to your title to any additional land, we cannot see any useful purpose could be solved by continuing a dispute with either Mr. Williams or Mr. Powell, especially since we feel that such a dispute would involve you in considerable expense and would be bound to fail. If you wish to maintain your claim to this larger tract of land, you may, of course, do so, but we have every reason to believe that both Mr. Powell and Mr. Williams would regard such action by you as being a trespass and would undoubtedly commence proceedings against you. If you wish to pursue the matter any further, we strongly suggest that you place the matter in the hands of another attorney before taking any further action. Since we feel that we cannot usefully help you further, we have enclosed our bill for professional services. We have in our possession various documents handed to us by yourself and will be happy to return these on settlement of our account. Yours faithfully, Appleby, Sperling, and Kemp.
Do you wish to make any comments regarding this document?
Yes. Okay, so we first just want to draw attention to the name Gaius Powell, his name.
Yes, please proceed.
His name has been referenced previously as being, again, one of the individuals that has contributed to this loss of land. In addition, previously in one of the other pieces of evidence, I believe it was in the newspaper, John Darrow, or one of the authors of the letters in the newspaper, cited that Mr. George A. Williams had given back a piece of his tract of land after acknowledging that this land did actually belong to George Wellington Darrell. And then finally, we just wanted to bring attention to the fact that this letter is dated 1955 and that our family has been trying to get back the pieces of land that we have lost or have been unrightly taken from us since this date and since George Wellington Darrell was alive.
Thank you. The next document you wish to rely on is which one, madam?
It is the next document is a letter from Civil Rights UK.
How many pages does it comprise of?
1 page.
Is this a note or a letter?
This is a letter, and within the letter, it's addressed to Your Majesty the Queen.
Does it have a date?
No, there's no date listed here.
Where was this document obtained?
This document was obtained from, again, the many documents that John Darrow has accumulated during his fight against this case.
Do you know if this document was delivered to anyone or sent to anyone?
I believe that this document was sent to the Queen.
Of England?
Yes.
The document starts by saying that in further amplification
Yes, it does.
and ends before the law.
Yes, sir.
Application chairman is for this one-page document headed Civil Rights UK. First paragraph reads that in further amplification, and ending before the law that it be tendered admitted as exhibit HT 24. 25, I'm sorry.
You're requesting that one-page document headed Civil Rights UK document, a letter to, purporting to be a letter to Her Majesty the Queen, taken from the belongings of John Darrow, be entered as Exhibit HT 25. Did you wish to have the document read?
Yes, I wish to have it read. Thank you, Chairman.
Yes. If you would direct the witness to do the same.
Please go ahead, Madam.
Civil Rights UK, Justice House, 400 to 402 Brixton Road, London, SW9 7AW. That in further amplification of your petitioner's most respectful submissions, Your Majesty should mandate Your Majesty's Prime Minister, the Honorable Margaret Thatcher, MP, to instruct the government of Bermuda in your name that the entire case of the Crown versus Darrow, case number 124 of 78, should be withdrawn on the grounds that the Bermudian High Court misled itself into the factual findings that the Bermuda government had lawfully acquired the estate of Emilius Darrow and George Wellington Darrow's property, when the vestry records of 1971 proved that no such lawful acquisition was possible before 1971, and that such finding of fact is wholly erroneous in fact and in law, that the Attorney General was wrong to contend, and that the High Court perverse to ignore the fact that Mr. Walter N.H. Robinson, attorney at law as he then was, acted for the estate of George Wellington Darrow on the basis that such property was lawfully owned by the Darrow family, and then in 1978, sitting as Mr. Justice Robinson, gave a judgment upon the very same property, which was in direct and perverse contradiction of the professional acts he committed in 1964. That Your Majesty's Prime Minister, Mrs. Thatcher's visit to Bermuda on the 13th of April is consistent and wholly a product of the rule of law within Your Majesty's realm and colonies, and that Your Majesty should so instruct the Bermuda government as an act of constitutional celebration of the rule of law and to the proposition that all are equal before the law.
Thank you. Another letter to this, well, from the Civil Rights UK to Her Majesty Queen Elizabeth II, dated the 27th of February 1990.
For clarification, would you repeat the date, please, Counsel?
The 27th of February 1990. I'd ask that it be tendered admitted as Exhibit HT 26.
A document headed up Civil Rights in brackets UK, dated 27th of February 1990, be tendered in evidence as Exhibit HT 26. And if the witness could read the said document.
Please.
27th of February 1990, Her Majesty Queen Elizabeth II, Buckingham Palace, London, SW. Dear Your Majesty, first of all, our most respectful appreciation of the most gracious message you were pleased to honor us with upon the occasion of our annual dinner at the House of Commons, London, on the 27th of January, 1990. Your royal message was read out to our assembled guests and received with fervent expressions of loyalty and high and dutiful appreciation. We venture to write to you most respectfully because we have been troubled of late by complaints of what appears certainly at first glance to be serious and invidious erosion of civil rights in Your Majesty's right royal colony of Bermuda, in the matter of the conduct of Your Majesty's judiciary, in the matter of one John Nathaniel Darrell versus Your Majesty's Attorney General, acting on behalf of Your Majesty's government of the said colony of Bermuda. It is reported thus that one of Your Majesty's judges of the High Court of Bermuda, the Honorable Mr. Justice Hull, presided over the case of Attorney General of Bermuda versus John Nathaniel Darrell in August 1989. And whatever legal arguments may or may not be advanced in good time in the Bermudan Court of Appeal, or even Your Majesty's Privy Council. It is now February 1990, and there is still no sound or sign of the delivery of the judgment of the said Mr. Justice Hill. Justice delayed is justice denied, and we would most respectfully represent to Your Majesty, and we hope Your Majesty would not deem it unreasonable of us to ask that such judgment should be delivered now without further delay to Your Majesty's most loyal subject, John Nathaniel Darrell. The other aspect of our deep concern is that Civil Rights UK is most anxious to be present in the High Court of Bermuda at the time and day of the delivery of said judgment by the Honorable Mr. Justice Hull, and we shall most certainly need some prior intimidation of the occasion, but it would certainly seem that such prior notice is to be denied us. Thirdly, the Bermuda Court of Appeal, having first promised to deliver judgment in a related matter regarding the very same parties in March 1990, has now stated that such judgment is delayed until July 1990. Judgment delayed is just justice denied. And we, Your Majesty's most humble and loyal subjects here at Civil Rights UK, are most anxious and apprehensive as to the reasons for this most extraordinary and seemingly well orchestrated delay by Your Majesty's judiciary in what William Shakespeare called the vexed Bermoose. It would appear that the Bermoose is still a very vexed indeed with the litigants of I don't know what that word is, of John Nathaniel Darrell. It would also appear most timely to us to refer Your Majesty to what we found upon visiting Bermuda last year, the very colony in which Your Majesty's governor was once shot some years ago, and where very many Black people believe that the wrong men were convicted. There is absolutely no doubt that there is active, alive, and seething just below the cosmetic surface of Bermudan politics, a potentially wild, resentful, seething rage by many Black families that they have had their land stolen their land stolen most blatantly by the whites, and that the legal profession and Your Majesty's judiciary in Bermuda are distinguished only by their connivance and condonation of such large-scale land stealing, and your most loyal Black subjects believe, rightfully or wrongly, that Your Majesty's judiciary will pile delay upon delay in the Black Bermudians' quest for justice, since this accords with the unspoken and unwritten silence but well-known conspiracy to preserve the white man's larceny of Black people's land in Bermuda. To this extent, therefore, I would respectfully invite your majesty's right royal consideration to the reasons, real or imaginary, as to why the Bermudian judiciary is seemingly deliberately delaying judgment in a case which could affect the jurisprudential fortunes of your majesty's black subjects. Your majesty's humble and obedient and loyal subject, signed Rudy Narayan, Director, Council, Civil Rights, UK.
You wish to place reliance on a 16th March 1990 letter from the then Chief Justice Sir James Astwood to Rudy Narayan Esquire, Director,
Yes, I do.
Council of Civil Rights UK,
I do. Yes,
and you have that document there.
I do not.
Yeah, Council, would you describe that correspondence once more for my edification
Certainly.
and the record?
I crave your indulgence a minute.
I think he needs it.
It's in there. Yeah, it's in there. That was my one.
It is a letter on the letterhead of the Chief Justice's Chambers,
I had it.
signed by then Chief Justice Sir James Astwood. It's addressed to Rudy Narayan, Narayan Esquire. It's dated the 16th of March, 1990. It consists of 2 pages.
With that description, Council,
Thank you.
you wish to now give it a exhibit number, HT
That's it.
27.
27, I would presume.
Thank you.
I didn't presume to repeat all of that.
That's fine. You may proceed to read the letter, Madam.
Chief Justice Chambers, 21 Parliament Street, Hamilton, Bermuda, HM 12. The 16th of March, 1990. Rudy Narayan, Esquire, Director, Council, Civil Rights, UK. Justice House, 400 to 402 Brixton Road, London, SW9 7AW, England. Dear Sir, I received on 16th of March, 1990, the copy of your letter dated 27th of February, 1990, which you have addressed to Her Majesty complaining about a number of things, but in particular, making the most unfortunate assertion that the legal profession and Your Majesty's judiciary in Bermuda are distinguished only by their connivance and connotation of such large-scale land stealing, and your most loyal black subjects believe, rightly or wrongly, that Your Majesty's judiciary will pile delay upon delay in the Black Bermudans' quest for justice, since this accords with the unspoken and unwritten and silent but well-known conspiracy to preserve the white man's larceny of Black people's land in Bermuda. I find the allegations concerning the judiciary of Bermuda most repulsive. It is completely unfounded. I readily accept that there has been some delay in the Court of Appeal and the Supreme Court in rendering these judgments, but if properly reasoned and considered judgments are to be given, then these will necessarily take time. But I am satisfied that the judgments of both courts will be rendered within the proper time limits open to these courts. You should be informed that our Court of Appeal is an itinerant court and sits normally in Bermuda 3 times a year. The judges of the Supreme Court render their considered judgments as quickly as they are able to within the time available to them. Public notice will be given by the court when the judgments are to be delivered, and you may care to avail yourself of it. I would expect to receive from you as soon as possible an apology for your unfounded and unsupported attack on the judiciary of Bermuda. Yours faithfully, Sir James Aswood, Chief Justice. And the response? 20th March 1990. Dear Sir James, I must say I am profoundly grateful for your swift and direct response. You will appreciate that from this distance, we are very much at the mercy of information supplied to us by persons in Bermuda as to the truth or untruth of what we asserted to Her Majesty. That is why the phrase rightly or wrongly was most carefully inserted. However, the belief is that in the minds of Black Bermudians is without any shadow of a doubt, because I was most conscientious in the nature and extent of my inquiries when on the island. Whether such belief is well-founded or not may have to be in the subject of further inquiry, and probably more in line with persons of your lordship's eminence and distinction rather than lie with my humble self. Nevertheless, in the context of the shooting of the governor and in the commissioner of police in this not too distant past, I thought it right to draw this widespread and deep felt feeling among Black Bermudians to Her Majesty. Believe it or not, I prefer to speak out and let the steam out of the kettle rather than allow steam heat to become violence and assassination. I am sending, if you don't mind, copies of this correspondence to Her Majesty so that she should know firstly of your finest repudiation and rejection of what I have written, and secondly, that she should have this clarification of my own first letter to her. Should you please note my respect and appreciation of the clear stand you have taken in these matters. I do hope I have not been misled or misinformed. At least I very much hope not. Your lordship's most respectful servant, Rudy Narayan. P.S. If you can actually convince me that I have been wrong, then of course we would gladly apologize.
I would like to speak to that if possible. Donald McMahon. Okay. Mr. Ryan came to the island and they came up my grandmother's house. And basically my uncle had arranged a lot of people that had land problems, and they all came to the house and they was all telling them about their problems. That's where this letter came from. Just for, okay.
And how do you know this? How do you know this?
I was up there. I was at the house when this happened, and I was surprised that a lot of the issues, when people were bringing stuff up, it was like mind blowing for me. All the areas that they was talking about.
Thank you.
Yeah, Counsel, would the witness further expand on that and with perhaps a timeline, just for the record, if you could remember, as close as
I
possible?
can't remember the date exactly.
Oh, clear, as close as you can.
It was in the late 80s.
Late
Late
80s?
80s. I can't remember exactly what date. But I can show pictures of the Brown family. They were there to the meeting, and they went around to different areas and taking pictures and stuff like that.
All right. Yeah, Counsel, you may continue. I didn't wish to break in, but I wanted to get some timeline of when this event occurred, if possible.
That's fine, Chairman.
Okay. Not to interrupt, but my cousin just showed me it was in 1989.
Thank you very
showing
much.
a document,
It's just a newspaper clipping.
and the newspaper clipping is in reference to what?
Darrell family cleared the road, and it says, and Rudy Narayan barrister said, so it was
Just
in,
a minute.
I'm
You
sorry.
wish to rely on that document,
Oh, yes, yes.
and you wish to rely on it for what purpose? To prove
No,
to establish.
the commissioner asked me, when was it here? When did he come?
So
I
you'd
said it
like
was
to use that document to
just
establish
to say the timeline. Yeah.
Yes, okay.
And what is the extract? Is it taken from in a newspaper?
It's, the headline just says Darrell family clears the road. It doesn't. I'm assuming it's probably the road because it's just it doesn't have the name of the paper.
Okay.
And Counsel, would you want to label this as an exhibit?
I would like to see first.
Yes.
Jordan. Your mama's school.
I crave your indulgence. Chairman, it's an extract from what appears to be a tabloid. I'm uncertain of which tabloid it is. It's just has as its title February 23, 1989. Friday, June 23, 1989. And the title is Darrell Family Clears the Road. We'd like to have it tendered and admitted as an exhibit.
Yes.
HT 28. And whilst it's being projected on the screen, I'd ask that the witness could read the document for us.
Yes, we record that copy of photo showing the Darrell family clears the road, taken from a document, photographic document dated June 23rd, 1989, being tendered as exhibit HT 28.
Thank you. Craven. You may go ahead, madam.
Friday, June 23rd, 1989. Darrell family clears the road. A leading English civil rights activist yesterday claimed up to 30 Bermudian families may have been cheated out of millions of dollars of real estate during the past 3 decades. London barrister Mr. Rudy Narayan further alleged those responsible for cheating Bermudians held respected positions within the local community. Mr. Narayan has been hired by Mr. John Darrell, the man involved in a 27-year land dispute with the Bermuda government. Mr. Darrell and his family yesterday claimed a major victory in their marathon battle when they officially opened Tribe Road Number 4 in Warwick. Mr. Darrell said 2 generations of his family had argued government boundaries were incorrect and the road belonged to them. It has only been within the last 7 days that government has moved boundary markers back to show we were right all along, he said. During the ceremony, Mr. Darrell's mother, Mrs. Bernice Darrell, cut a ribbon held across the road by Mr. Darrell's 2 sons, Nathan and John. The Darrell family said the road would be open to all. Mr. Darrell said the ceremony, which was watched by about 6 other Bermudian families who also claimed to be victims of unfair land deals, was to mark the beginning of another phase of his fight. The road represented just a portion of his battle to regain land he claimed belonged to him, he said. He will appear in the civil court on August 14th to continue the fight, he said. In the lead up to the case, Mr. Narayan, along with several other international civil libertarians, will meet with other Bermudians who claim unfair treatment at the hands of government and property developers. When Mr. Darrell blocked this road many years ago, he was threatened with prosecution. Now, 27 years later, he has been proved to be in the right, Mr. Narayan said. How many other land boundaries are wrong, and how many other Bermudians are going to have their land returned to them? Mr. Narayan said. A meeting of all other families who believe they had a rightful claim to land would take place next Thursday at the Darrell's residence. He said he would issue a press statement after the meeting detailing what occurred and what further action might be taken. Mr. Darrell said he was forced to sell a house and he had given to his son to finance Mr. Narayan's trip to Bermuda. He believed the cost and effort were worth it because so many Bermudians had complained of unfair treatment regarding land deals. People have come to me in the street and asked how I could help them, he said.
Thank you. Now, earlier you had made mention of the judgment of Justice Robinson. When we sat yesterday, you made mention also of concerns of Mr. John Darrell. Today, you also made mention, reading correspondence, that Mr. Darrell, John Darrell, was concerned that Justice Robinson, before he became Justice Robinson, he was Mr. Walter, and still is, Walter N.H. Robinson,
Attorney.
and he appeared, attorney, barrister at law, and he appeared for Mr. George Darrell. I'm going to show you a letter which you have shared with us, dated the 17th of June, 1963. It's on the letterhead of Walter N.H. Robinson, Temple Bar Building, Church Street. You have a copy of that document there, madam?
Yes, sir.
I'd ask that document on the letterhead of Walter N.H. Robinson, barrister at law of Temple Bar Building, Church Street, dated 17th June 1963. It's tendered and admitted as exhibit HT 29.
You just have a letter on letterhead dated 17th of June
1963.
1963 from lawyer Walter Robinson of Temple Bar Limited, Church Street, be tendered and examined in evidence as HT 29. Sit down.
You may read, madam.
Walter N.H. Robinson, barrister at law, Temple Bar Building, Church Street, Hamilton, Bermuda, 17th of June, 1963. Mr. George Darrell, Riviera Estates,
No,
South-
Mr.
Mr. Riviera Estates, Southampton East. Dear Sir, I have not completed my searches relative to the boundaries of your property at Southampton, and am continuing to investigate the same. In the meantime, I should be pleased if you would pay me a retaining fee of £10 and 10 pence,
Shillings.
shillings, pardon me, For this matter, as per the enclosed bill, should this matter go to the Supreme Court, the retainer will be taken into account in fixing fees at that time. Yours faithfully, signed, Walter N. H. Robinson.
Wish to make a comment on this document? Mr. Ma-
Oh, yeah, this is basically the,
State
I'm
it.
sorry, Donald McMahon. This is basically showing that he worked for my grandfather doing the searching for the boundaries for the land.
And in respect of it is more or less said, well, a similar issue that was before when he was judge that he dealt with.
Yeah, dealt with the same
And I think
conflict of interest.
and Mrs. Fishington had spoken to that matter earlier today also.
Yes.
Yes, sir.
Yes,
Thank
Haley Tiart. Yes, this letter supports not only John Darrell's claim that Mr. Robinson was wrong to judge on the matter related to the Darrell property, but also the civil rights individuals who also wrote to the Queen saying that the judgment should be thrown out because Walter Robinson had previously worked for the Darrell family in relation to the same land that was ruled on in that court case.
And Donald McMahon. And he also worked for the Sunnyside Park before he worked for us. So that's two areas that's affecting the same property.
And Sunnyside Park,
It's just up the hill from the Darrell property.
and about who they,
Walter Robinson was the lawyer doing the search up there too.
and were you in dispute with Sunnyside?
No, what I'm saying is the property goes right up to the Sunnyside Park. So he was aware of both situations. That's what I'm referring to.
Haley Tiart, the property actually includes a few lots of Sunnyside Park. Yes.
Thank you. The next document you wish to rely on, Madam? What is that?
This is an indenture made between George Arnold Williams, and it also includes Gerald Alexander Simons and Walter Nathaniel Harvey Robinson.
What's the date of it, Madam?
This is the 11th day of March, 1953. 1953.
Thank you. It consists of how many pages?
It consists of 10 pages.
Thank you. I'd like to ask that I document the indenture consisting of 10 pages, made the 11th day of March, 1953. It appears to be a yellow circle, NO5A. I'd ask that it be tendered and admitted as exhibit HD 30.
Study. You'd like to tender 10-page indenture dated 11th of March, 1953, with the yellow mark number 5A attached. And who's it between, with the name, the presidency, the
Ms. Tiart, who
Two
is
people
it?
Pardon me.
involved?
Yes. George Arnold Williams, Gerald Alexander Simons, Walter Nathaniel
Too
Harvey.
fast, that's too fast. You're going too
just,
fast.
Pardon me.
G.A. Williams, yes.
Yes. Gerald Alexander Simmons, pardon me.
SI, how many M's?
2,
Simmons? Yes,
and Walter Nathaniel Harvey Robinson.
and that is the same person who was a lawyer previously?
Yes.
And that is standard in evidence HT as HT. Thank you. Counsel, I just want to make mention that I intend to continue this matter until 4 o'clock so that our commissioners, 2 of our commissioners then can take care of some personal business.
Very well. Very well. Miss Tiart, well, following up on the question of the chairman, the name you just read, Walter Nathaniel Harvey Robinson, just and it says of the city of Hamilton in the islands of aforesaid barrister at law. What is the purpose of this document?
The purpose of this document is to further explain or give proof of Mr. Walter Robinson's dealings with not only property in the area, but also with George Arnold Williams, who has also come up several times in relation to his claim to property that actually belonged to Emilius Daniel Darrell.
Forgive me. So before you were bringing to our attention the fact that before Walter Robinson Esquire became a judge of Bermuda, he acted for Mr. George Darrell, and he was here requesting that he would be pleased if you'd be paid his fees. We then have a complaint by Civil Rights UK written to the Queen. Then Chief Justice Sir Ashwood chose a prudent route of writing to the Civil Rights UK and not the Queen, of course, to complain about the letter written to the Queen. But now you're exhibiting a document which, please just repeat it for me.
It just further.
The deed. Who are the parties and what is happening?
The parties are George Arnold Williams, Gerald Alexander Simmons, and Walter Nathaniel Harvey Robinson. And this is an indenture, so this is transfer of property.
No, this indenture is dated 11th of March, 1953. The letter written demanding my apologies for choice of words, inviting payment of fees due, is dated the 17th of June, 1963. And the judgment in the case
1978.
is 1978. Yes, you may continue, ma'am, in terms of you don't need to go through the full indenture, but if you could just highlight to us, for us, the parts that you think are relevant.
Okay. So we actually could go back to the the page where the map is. I think,
Sorry.
yes.
What, you mean the same indenture?
Yes, the same indenture. There's a map attached.
Yes, you may proceed, madam.
And at the top of the map,
Sorry, just before going any further, just to indicate that in the bottom left-hand corner, it indicates plan of land known as Sunnyside Park, Southampton Parish, Bermuda. That's right there. I think, oh, yes. Yes, but you want to show somewhere else.
yes, I just wanted to draw attention to the top part where it says the land of the colonial government, old boundary stone wall.
Yes, speak a little louder for us, yes. At the top, it has Gerald Alexander Simons.
Yes.
Yes, proceed. Thank you.
And there specifically is at the end of this document, there's a receipt dated we saw this already, but it's the receipt dated 1954. And this is from 1953. And so it says the land of the colonial government, and pardon me because we are trying to piece together this evidence left behind by John Darrow. But one of the things that he wanted us to pay attention to is the fact that this area of land, which is recorded in other maps, the land of the colonial government, which is recorded in other maps as being that of John Nathaniel Darrow or George Wellington Darrow. Here is the land of the colonial government, 1953, but the receipt shows that tax was paid to the vestry in 1954 on that land. And that's evidenced on the last page with the receipts of the state of Amelius Darrow, 1954. And so that was just to outline one part of inconsistency, not only with the names Robinson and his relation to George Arnold Williams in the indenture, but also on the map that was used in that indenture, where the colonial government is cited as having ownership to that land, but tax was paid on that land on the estate of Amelius Darrow as early in this point as 1954.
No, if you could just guide us. I know you had drawn our attention first and foremost to the map, and you had, by way of speaking, highlighting the area almost rectangular that speaks to the land of the colonial government. You're saying that what appears to be almost rectangular area, stone, you're saying that the receipt which follows evidences payment by Mr. Darrell for that land?
Yes, sir.
And how in terms of the receipt, how are you sure it is that piece of land that is being paid for and not another in terms of the lot numbers or the numbers given?
Nathan Darrow.
Sure, go ahead.
By looking at the plan, it doesn't show any estate of Amelius Darrow. And the plan is from, was stated 1953. And also the area where it says Arnold Williams, which is on the left-hand side there. And
Just a
also
minute.
marked,
Arnold Williams.
it's kind of cut off. But the assumption is George Arnold Williams.
Can you just assist me in terms of the area that you're referring to, where it has at the top the parcel that has the number 60, 48, 60, those measurements? Is that what you're referring to, that rectangular?
No, to the left of that, where the dark shading area is, on
Yes.
the other side of that, right?
Oh, okay. Where Arnold Williams appears on the left, the name there, yes?
Yes, this land that says Arnold Williams is actually part of the Emilius Darrell estate. And this plan does not show Emilius Darrell to earn anything on this plan. But yet, back here, he's paying taxes on land.
He's allowed to pay taxes, and your view is that the Southampton vestry would not allow someone to pay taxes unless they're an owner. Is that what you're saying?
That is correct.
Go ahead, Mr. Martin.
Could I intervene in that there too? Donald
State it.
McMahon? Okay, going back to the police report in the mid-ocean, I'm just gonna read from a section of it.
So, just a moment. To know what number was it? What number was it for the mid-ocean? Witnesses drawing our attention, thank you, Chairman, to HT 12. So McMahon is drawing our attention to that document, and he wishes to
Yeah.
Yes.
speak. We're having the document projected on the screen.
Okay, reading from, was it Inspector Card or from
You're reading from the
Card document on the second, far right, A 1943. That's where I'm reading from. It said, A 1943 deed subdivision is respected of property then in the ownership of George Arnold Williams, formerly owned by Horace Cooper, 1928, and then owned by Orwell Ralph Lublin. After that, shows that property to the north was owned by the estate of Joseph DeRosa, and to the west by the estate of Emilius Darrell. In 1956 deed in respect of Mr. Anthony Rabin, his house is right up on the top of the corner there where the colonial government land is, or where it says it's the land. Mr. Anthony Rabin further confirms ownership of the property belonging to the complainant's father, George Darrell, by referring to the estate of Emilius Darrell. So that there, in essence, is showing that in 1956, it was recognized as the estate of Emilius Darrell, right up top of the hill. And Mr. Rabin's house will be number, what's that, 31 or 32? That's where his house is, 32. So that's just to draw a reference.
thank you.
Haley T. Art,
Just a moment, please.
no problem.
Go ahead, madam.
I also just want to draw attention to the bottom of the plan. Who drew this plan was Mr. Wycliffe Stubble. And as Nathan said, a portion of George Arnold Williams' property was also a part of Emilius Darrell's estate. And in some of the previous documents we put into evidence, it was said that Wycliffe Stubble not only made this plan, but also performed some things that was in the benefit for George Arnold Williams to make some of that property his own. And as you can see, it says to be conveyed to Wycliffe Stubble, the bottom portion or below of George Arnold Williams' property, which would be considered the estate of Amelius Darrell.
I was going to ask you to repeat that point for us, please. Please, and just speak a little louder for me.
So we previously, in some of the previous evidence, it was said that a portion of George Arnold Williams' property was actually a part of Amelius Darrell's property, and there was also evidence showing that Wycliffe Stubble did some things to the benefit of himself with the help of George Arnold Williams' property to place some of that property in his name. And here below, we see that in this document itself, which was drawn by Wycliffe Stubble, right below George Arnold Williams' property, what's been sectioned off to be his property, it says to be conveyed to Wycliffe Stubble.
You said to be conveyed to?
Yes.
Where?
It's the lot where you say 60 is right below what is said to be George Arnold Williams' property on the far left of the map.
Oh, yeah.
And this is the map that
Just,
was,
just a moment,
sorry.
please. Just a moment. You're referring to where that measurement is 60.
Yes.
Oh, yeah, there's one here. That's what you showed me. So where the cursor is now, I don't know if you can see it.
Yes, sir.
Right, so just there. So you're saying right where it says
That's above
60, pardon me?
Let me say it's to be
Right
completed.
here.
Wait. So where it has 60, that rectangle, the words are to be conveyed to Wycliffe Stubble, and it has 52.
That's the lot number.
Right. I'm just, yes, sir. Thank you. I was just indicating that that's the area that you're referring to, madam.
Yes, in terms of
Got
the
it.
area that in one of the documents, John Darrell said that Wycliffe Stubble acted with George Arnold Williams to benefit himself and gain a portion of that property.
Now, having said that, do you wish to make any comment? Please go down to the, okay, go down. This document, as I had read earlier, it says plan of land known as Sunnyside Park, Southampton Parish, Bermuda, referred to in the annex indenture, survey, subdivision, and plans by Wycliffe, I think, Stover, architect, surveyor. Do you wish to make any comment in that regard? You showed us an error first where it says to be conveyed to Wycliffe Stover, and the said document is prepared by Wycliffe Stover. Do you wish to make any comment in regards to that?
Yes, I think this suggests some issue by the fact that Wycliffe Stubble, Walter Robinson, George Arnold Williams, all names that have been mentioned
Don't be
before.
speaking too fast.
Sorry, all names that have been
So
mentioned before.
Start
Okay,
again,
I
please.
wasn't gonna do this here too. I just want to show.
I think that the fact that Wycliffe Stubble, Walter Robinson, George Arnold Williams, all names that have been spoken to before in the previous documents provided in evidence, this speaks to some element or issue in terms of the ownership, not only of property but also maybe dealings between the three people, dealings that have wrongly been represented in court as well, because I believe this map was also used in one of the court hearings against John Darrow, but it's just evidence, again, to the multiple people involved in the land grab of the Darrow estate.
Thank you.
Could I,
Thank you.
could I make a comment?
Please, just
Okay.
state your name for me, sir.
Donald McMahon. I'm going back to the Applebee's Sperling Camp letter of 5th of August, 1955.
Just a moment, please.
No.
I'm done.
Somebody else is there.
Yeah, yeah, okay. Let's let me figure it out. Yeah, well, need to find a document he wants. Could you just hold it up so we can find, just hold it so I can see. What date is on it?
5th of August, 1955.
Witness wishes to refer to Exhibit HT 24. You may go ahead, Mr. McMahon.
Okay, this is describing the area that Mr. Powell says belongs to the estate of Emilius Darrow. He says the land, Mr. Powell was speaking to us both as the parish vestry clerk of Southampton and also as a landowner in the vicinity of your property.
Just speak a little louder for us, please.
Okay, sorry. He tells us that the parish vestry records show that a piece of land measuring approximately 100 feet by 70 feet was in the possession of William Green Darrow in 1964. In 1981, it was in the possession of Daniel Davis Darrow, and in 1939, it was entered in the vestry books as being in the possession of Emilius Daniel Darrow, and thereafter in your own possession. Within this long period of time, nearly 100 years, there is no record of any other land in the vicinity belonging to your predecessors in title. Mr. George Arnold Williams confirmed these same facts to us at the time of his interview. We have today had a consultant with Mr. Peter Smith of Measure Hallett, Whitney, and Patton. Mr. Williams' attorney, who has shown us Mr. Williams' title deed to a tract of land somewhat larger than 5 acres situated to the south of your small lot. Mr. Williams' deed shows a clear title back to the year 1928 and recites a title going back to the later part of the 19th century. On examining Mr. Williams' title deed, we are satisfied beyond any doubt that these deeds are in perfect good order and that there is no question that at least against yourself, Mr. Williams, has a good title to this tract of land. Basically, the land that they're describing, since they put my grandfather's area in just in a small spot, where they have colonial garden, I'm governor, right down there is George Arnold Williams runs right down to my grandpa's park. So you got George Arnold Williams owning that property, you got colonial government owning that property, and you have deeds showing where my grandfather owns that property.
Saying all can't be true.
Well, my uncle made a statement he said there's too many thieves in the pot. That's the statement he made, and everybody was protecting themselves. So I'm just reading the evidence that they're saying that, you know, you saw the Sunnyside Park where George Arnold Williams stopped up top of the hill, and you saw colonial government.
Don't go so fast, please.
Okay.
Let's repeat,
sorry.
but just speak a little slow.
Okay, on the Sunnyside Park, that the plan that we showed you just now, you saw George Arnold Williams up top of the hill, and you saw straight across, you saw colonial government. Then I read from Mr. Card's statement from Rabine's deed, which said to the west of him was Emilius Darrow. Now reading from F.D. Sperling Kemp's letter from Gaius Powell saying that Emilius Darrow just owned a small piece of property, and on the south of his boundary was George Arnold Williams, a tract owned by George Arnold Williams, which went back 100 years, as he says. So I'm just saying that's 3 different people within a short time.
Thank you very much. Mr. Chairman, I think it's a sufficient time to cry bad light based on the evidence so far and what has been said and your indication earlier as to the adjournment at this time.
Yes.
I think it would be sufficient time to take off the bails.
Yes, Counsel, I agree. I want to thank the witnesses for the testimony in continuation of the claim. And if I, Counsel, if I can get an indication of when we're going to
Monday morning at
resume-
10,
resume this matter,
on 10 o'clock
and
Monday
if the
morning.
witnesses would return at Monday morning at 10 o'clock to resume your evidence. Thank you very
Okay.
much.
All right.
And Counsel, any other matters before we adjourn?
We continue tomorrow at 10.
Right, correct. Thank you. This hearing is adjourned for the day. We return at 10 o'clock tomorrow morning.